Hello, my name is Youngran Christine Kim, and I am an associate professor of law at the University of Utah, S.J. Quinney College of Law. I'll serve as the moderator for this panel, which is titled Upper Level Curriculum. And our panelists today are Professor Anastasia Boles and Professor Bridget Crawford. Professor Boles is an associate professor at the University of Arkansas Little Rock, William H. Bowen School of Law. Professor Boles currently teaches civil procedure, evidence, employment discrimination, and race in the law. As a scholar, she has published articles on employment law, culturally proficient legal education, and criminal justice policy. Professor Boles co-directs Bowen's new Center for Race Justice and Criminal Justice Reform at Bowen. The next panelist is Professor Bridget J. Crawford. She teaches federal income tax, estate and gift tax, and will trust and estate at Pace University Elisabeth Haub School of Law. Her scholarship focuses on issues of taxation, especially wealth transfer taxation, property law, especially will and trusts, tax policy, and gender and the law. Professor Crawford's scholarship has been published in journals, including the Washington University Law Review, the University of Chicago Legal Forum, Boston University Law Review, UC Davis Law Review, Washington and Lee Law Review, and specialty journals at Harvard, Yale, Columbia, the University of Pennsylvania, and the University of Michigan. Professor Stacey Lees is another panelist, but unfortunately she cannot join us today due to unexpected health issues. So we may end this panel and wrap up the symposium a bit early today. After the presentation, we will have a Q&A session. So please feel free to submit your questions using the Q&A feature at the bottom of your screen at any time during the presentation. So without further ado, I'll now turn the time over to Professor Boles.
Good afternoon, everyone. I just have a few slides that I will share. So thank you for that warm introduction, Professor Kim, and for everyone at the Utah Law Review and Professor Leslie Culver for the invitation. I wasn't able to be with you yesterday, but I've been with you today, and it has just been riveting. I'm always struck by how much I learn by these conversations, so I appreciate the opportunity. So my comments today are going to move from my prior scholarship applying the paradigm of cultural proficiency to legal education. And I'm going to use this to try to add to the conversation of looking at barriers and recognizing and integrating issues of race, sexuality, class into the upper level curriculum. Ooh, I'm getting a little feedback there. Anybody else? Sorry. Okay, thank you. So I want to quickly explain how cultural proficiency can, I think, aid our work. But because the previous panels, particularly the last panel, have covered a lot of these ideas so well, I want to move forward into specifically some ideas I have about the upper level curriculum. But first, let's go ahead and orient ourselves. So there are many tools of cultural proficiency, but I wanted to offer this basic definition from educator Dr. Kikanza Neri-Robbins. And we've heard a lot of this language today in Professor Oakes, Professor Tully, that cultural proficiency is an inside-out approach. It focuses on the insiders of the school, encouraging them to reflect on their own understandings and values, and relieves the outsiders from doing all of the adapting. So let's break this apart a little bit to frame the discussion. So first, an inside-out approach, and we've heard this, throughout the conference, that this work has to start on the inside and reflect in. So that could mean many things. It can mean the professor, the school, the student, right? Just making this decision, engaging in the work, and reflecting outside. So I do a lot of workshops and working with schools on this effort. And I noticed that whether it's lawyers or educators or just A-type personalities, we tend to jump to the product. Okay, so we'll have a lot of conversations about what teaching methods can we use that are more inclusive, or how can we increase access to justice? And really what I am focusing on is who we are, not necessarily what we do. So again, that can be who we are as a school, who are you as students, who we are as professors, what are we going to do that is going to reflect out our work and therefore make changes to the system that we are trying to intervene in. The second part of the cultural proficiency framework is another theme that has been discussed throughout the conference, which is what I love. It's really bringing together a lot of these ideas. And that's the idea of shifting the burden on doing the change from those that we identify as outsiders. We can say people of color or women or whatever label we use, marginalized. It's the same that we're looking to those people, that group, to do the adapting, right? So if there's a practical lesson from the last 18 months, it should be that students of color, marginalized students, faculty simply cannot do this work alone. Right, we had an inflection in the system and really demonstrates how all of this broke down. Professor Merideo shared with us this morning how hard this has been on students and faculty alike. So I found it interesting that, let's see if I have a slide on this I wanted to show you. So the Black Education Research Collective at Columbia University released a report in July 2021 and talked about the disproportionate and traumatic impact that COVID and systemic racism, both that was exacerbated during COVID and the George Floyd protests, have really had on Black students and families. Yet there were several discussions. New York Times ran some opinion pieces. This is an NPR article about how Black professionals and Black students in some ways benefited from remote learning, because without that daily experience of racism, that some students and Black professionals felt relief at not having to engage in the daily trauma of racism in school hallways. And so that really struck me, that some of my students of color might actually feel more comfortable outside of the building than inside, despite my best efforts. And as I looked to some of my colleagues, not just in my building, but around the country, I saw that while there was a focus on kind of dealing with the pandemic, shifting to remote learning, that there was not necessarily the same attention paid to how to discuss these issues, how to bring race into the remote environment. So I wanted to talk through some ideas that I had for doing so quickly. And then leave time for brainstorming in the Q&A and in the chat. So the first idea is that the mission of diversity and inclusion and racial justice really has to be one that guides the institutional structure and priorities. It cannot be something that is slapped down, as we have seen in classes at the end of the day. So with the upper level curriculum, we have a little more room to expand beyond what traditional subjects like civil procedure can do. So in my employment discrimination class, I have much more room with the syllabus and with class discussion than I have in my civil procedure class. However, as we've already explored, there are many reasons why leaving diversity topics in these silos replicates the very racism of legal education. And so I can encourage law schools to think about how to institutionalize these structures. So we've talked today, even in the last couple panels, about having learning objectives, upper level requirements, either writing requirements or course requirements, developing course concentrations, also having administrative policies and priorities. Last panel, we talked about upper level tenure review. But the point is that we have to have a sustained institutional focus on this. And this is something that both faculty and students should demand. And so one way to think about this is, how would we deal with a bar pass problem? How would the school respond? What are the multiple ways the school would respond? And we can think of all of those ways and how broad that response would be when we think about trying to talk about race in the curriculum. Okay. The second point that I wanted you to think about is, how can we value the conflict that is created by inclusion of diverse perspectives? And so as I've gone and participated in dozens of these talks, either through workshops or in conferences, I'm often struck by how fearful many law faculty can be. And when I sit in office hours, I'm often struck by how fearful many students can be. So we have to learn to value this conflict and bring in discussions of race. And I'm not going to spend much time on that because it is something that we've talked about a lot over the last couple of days. Third, I want you to think about how we can shift the burden on diverse students and faculty. And so we've heard a lot of that today with how burdensome it can be, either on faculty members or on faculty who teach certain classes. It is no longer the case that we can expect Black faculty to carry this load, and we can, or faculty of color or women faculty, and we certainly can't expect our students to do it in class. So here's a personal example, because I really do try in thinking about cultural proficiency to start with myself and to reflect on my own challenges and mistakes. I recently taught race in the law. I taught it for the first time last spring. And it was a new course at the law school, and it was part of our effort to expand racial justice curriculum. I taught it online, which had some benefits and challenges. And I really tried to over-prepare because I was trying to be very intentional and make sure that I wasn't placing the burden on students to carry the discussion of this material. So I did all the right things. I actually took out Professor Tully's article and kind of and went through and all the things I was supposed to do in my own work. Yet, when we came to discuss a really hard issue that came up in a student's identity, that student skipped class. And when I went back to that student, the student confirmed for me they did not feel comfortable putting under the mirror in that discussion. And they worried about having to articulate the perspective. That was a huge disappointment to me. It was probably one of the harder things that I've dealt with professionally, because I intentionally tried to create this environment, and I felt that I had failed. But what I realized is, number one, I can do better next time. And number two, my support of that student had to extend beyond the classroom. And so I had to step out of Zoom or whatever it is and deal with the fact that this student was having multiple conflicts based on the pandemic. Not only were they uncomfortable, there's a lot going on. I had looked at how I might bring race into the classroom during class discussion, and I missed treating this student as a person, right, outside, and really trying to reach and support them. So one reflection, and we're not going to get it right. We're not going to get it right, but we have to pick it back up. The last thing that I wanted to put forth for you to think about is how can we increase opportunities for students to gain these experiences beyond the classroom. So I recently helped found a Center for Racial Justice and Criminal Justice Reform in Little Rock. And as part of our work, we really wanted to bring in opportunities for our students to not just talk about race or racial justice in our classrooms, but to actually get out in the community. And so we wrote a grant and were awarded $1 million grant. And so for the next 3 years, we'll be putting students up to 20 per semester in Arkansas courts. So we'll have them in district courts, which is kind of where all cases start. We'll have them in circuit courts where more serious felonies are. And I will tell you that these team meetings, I thought they were going to be an hour long every week. They have gone 2 to 3 hours every single week because our students are boiling over with what they're learning. And I think that there's a real role for those of us who consider ourselves doctrinal professors, who don't have necessarily a clinical background, to take our upper level courses even further beyond the classroom than we thought we would be comfortable in. Because it is really the case that interacting with these outside experiences has given me much more of an opportunity to talk with my students about these issues than I would ever have in a classroom. So I will leave it there and pick up the rest if you would like in Q&A.
Thank you so much, Professor Boles. Our next panelist is Professor Bridget Crawford.
So my topic today is very much in reference to and in conversation with all of the speakers who have come before me. So I want to thank everyone who put this amazing program together. It's complex, it's important. And I want to give a shout out to all of the organizers and presenters and audience members who have caregiving and other responsibilities on the weekend, separate and apart from their law school related work. There's a particular irony in talking about diversity, equity, and inclusion on a day when we know that those who have the greatest caregiving responsibilities in particular may find it most difficult to take part. And of course, schedules being what they are, sometimes important programs do flow onto 2 days. I myself have scheduled professional programs that take place on evenings, on weekends, sometimes both days of the weekends. So my purpose in mentioning that is not to call anyone out, but rather to call us in this very last panel of the day for that continued conversation, to call us in to again ask, what does diversity, equity, inclusion look like in the upper level classroom? And to say that, at least for me, if that means that you've got a cat walking across your keyboard and a kid who needs your attention, an elder who needs your companionship, that is completely understandable. If you toggle in and out of the session, you are welcome exactly as you are right now when you can join us. I want to tell you a little bit about myself. I teach at Pace Law School in White Plains, New York, which is really a suburb of New York City. A fairly large percentage of our student population is comprised of first-generation professionals, if not first-generation college graduates. The size of the student body is about 700. We have a part-time program and a full-time program with evening classes and Saturday classes. In terms of students' self-identified race or ethnicity, the student population is about 66.5% white, 9.5% Hispanic, to use the term used by the American Bar Association, 5.5% Asian, 6.5% Black or African American, and 8.2% biracial or multiracial. So about 40% of what 34% of what some people call people of color. My upper level courses include tax, wills, and corporations. This is a suite of courses that I affectionately call money law courses, borrowing from Alice Abreu's terminology. And for three of those courses, I have my own casebook, or more accurately, I'm the third co-author of a casebook for 3 out of those 4 classes. And that's part of the story that I want to tell. I don't recommend it for everyone. I'm not getting rich. I think I've bought one nice dinner with all of my royalties. It's not a labor for profit. It's a labor for love, or at least not profit for those who are producing the casebooks intellectually. So I want to talk about the when, how, do's, and don'ts of all of these things that many of us hold dear, beyond just the initials DEI, but difference, anti-racism, anti-sexism, anti-ableism, anti-trans, just about any other sort of anti-justice approaches. So my focus is fourfold: when, how, do, and don't. Let's start with the when. My answer is simple: early and often. One should talk about identity, including race. And how do I do that? In my wills class, I start on the very first day with a reading of the last will and testament of George Washington. George, you cannot talk about property law generally, and wills, trusts, and estates in particular, without talking about the fact that human beings were treated as property for a large part of our country's history, and even someone as venerated in history as George Washington was a slave owner and did not free his slaves upon his death. So I play into the students' familiarity with George Washington, mostly through Hamilton, but try to center the discussion of race early. In business associations, on the very first day, I mentioned that rates of stock ownership differs by race, gender, education level, and a whole bunch of other factors. So I'm always clear that when we are talking about ownership interests in corporation, we will be talking differently about different types of people. It doesn't mean that the law should be different, but that we should understand that we are already talking about a certain group of folks. And of course, for income tax, that case is proven very easily by a plethora of data. I usually show this chart on the very first day, showing that median household income in the United States has always varied over time. And so that when we are talking about income taxation, also, we have to keep our eyes on identity factors. It may be that tax is the area that unites all of us. Everybody hates to pay taxes. I don't care what income bracket you're in, what your race, gender, or ethnicity, or any other identity factor is. We are all united in the study of taxation and wanting to pay less on any given day. But what is not distributed equally, of course, is income. So that's just one concrete example of what I do in those three classes. I also include in my syllabus, I just give you an example here of my syllabus excerpt for federal income tax. We are now accustomed to complying with learning outcomes and stating those clearly. And I lead in my tax syllabus with the aspiration that students will demonstrate a foundational understanding of rules and policies and how those rules and policy may have disparate impacts as measured along non-economic identity axes. And somehow having it in the syllabus provides me with a way of referring to what it is I want the students to get out of the course. I don't think the students quite realize that I'm the one who writes the learning objectives for the course. So I exploit that slight efficiency gap in the knowledge. All right, let's move to a little bit about how. How do I talk about these things? And the reason I mentioned the casebooks in the beginning is because the best way to talk about any of these issues is to let the casebook do the work for you. And in that regard, be choosy when you choose your casebook. I joined the Federal Income Tax Casebook written by Dorothy Brown and Joel Newman precisely because it already raised some of the race and gender issues that interested me. Now that my name is also on the cover of the book, somehow still, again, the students, when they absorb the knowledge from the casebook itself, receive it differently than just the professor spouting off. It's in the book, therefore there's a legitimating function. Even though, again, my name is on the book, the fact that it is in this sort of fetishized thing called the casebook means something to the success with which students absorb the material. And there I would also add, you can let outside sources do some of that work for you. I am one of the editors of a series of feminist judgments books, and you might see the words feminist judgments and think, oh, well, that must be about gender. But every single one of these books also deals with intersectional identity issues related to race, gender, class, sexual orientation. I have another critical tax theory reader with Tony Infanti. So when the outside sources do the work there, that's another way that professors can ease some of the burden off them to initiate certain conversations. I want to show you how I do that, show you how I use one of those sources. How do I bring up these issues from any of these books in the classroom? All the tips I'm about to share with you come from a particular article in the Texas Law Review online. You can find it very easily. But the exercise goes something like this, and this is a case from the Feminist Judgments tax book about the tax-exempt status of Bob Jones University that discriminated against individuals on the basis of interracial marriage or interracial dating. And so what I do is I take the real actual Supreme Court decision, and I take this reimagined shadow opinion without telling the students which is which, and I put them both in the same font in a handout, and I ask the students to read them. And then I start asking the students to go through a variety of questions, including the ones I have here on the screen about how the two opinions varied, were there facts that came forward in one version or the other which was more persuasive, and then finally reveal to them which is the real court opinion and which is the so-called feminist opinion. And students are often very surprised to find out that what they have just spent 20 minutes discussing as the better, more well-reasoned opinion is not the actual court opinion, but the one that a professor writing from an explicitly feminist perspective, and feminism in the articulation of the editors is a broad project, a broad social justice project that includes multiple identity factors. Students are often very surprised. So that leads me to one of my core do's. So some do's and don'ts, and we'll see where we end up. My first do is acknowledge that we all have a race, a perspective, and a life experience. White people love to pretend that they don't have a race and that every other person is a person with a race, and that somehow whiteness isn't a race. But of course, we all have race, and race informs our perspective. Our life informs our perspective, and that's actually what drives those shadow opinions that I review with my class. I also find it helpful to acknowledge out loud, it's hard to talk about race. It's hard to talk about it in the classroom, and sometimes just saying those words when you're the one at the front of the classroom can help. One technique I've borrowed from my friend and colleague Phyllis Tate is assigning mini fact-finding projects for students. If they're on my panel for the day in business associations, I might ask them to go investigate a particular company, and what can they find out? Are the demographics of the board of directors, how many men, how many women, what are the either stated races or apparent races of the boards of directors. In tax, I might ask the students on call for that day to find out how many people in the county of their birthplace are homeowners and what data they can find about the race and gender of those folks. And I find often when students have engaged in the fact-finding project, again, this is Phyllis Tate's wonderful idea, but when students find the facts themselves, they become more empowered to talk about issues of race, gender, and other identity issues. I would say on my third do list, I've got 10 do's. Third on my list is that we, the person at the front of the classroom or the side, wherever it is you sit or stand, have to raise issues when your students don't. Don't rely on students. If you want to talk about race and gender and class, and none of the students raise it, then do raise it yourself. And if you don't feel comfortable raising it, guest speakers can be a fantastic way of having those conversations. There are pros and cons of education via Zoom, we all know, but having guest speakers from across the country Zoom into class is a wonderful benefit. I also find that it's worthwhile to emphasize changing perspectives as opposed to proselytizing, trying to make students have certain values. Because I don't think changing their values is necessarily my primary pedagogical goal. But it is a goal of mine to emphasize that when they change their perspectives, they become a better lawyer, they become a better advocate by taking race into account, by taking gender into account, by taking gender identity into account and understanding the world from a client's perspective. You will be a better advocate. And because law is a service profession, I now respond to students who love to say, well, I don't see color, which of course is, of course you do if you are a visually able person, you do see color. But that's never been effective in changing a student's mind. But when you tell them that a jury will see color, or you tell them that an adversary will see color, that somehow appeals to their professionalism. Borrowing from Phyllis Tate's example, I also rely a lot on facts about corporate ownership, about who is taxed by what laws, etc. I very often find myself prefacing my statements very clearly by saying, I am not about to make a political statement, I'm about to make a statement of fact. And I at first did that as a defense mechanism, but now I do it because I want to be very clear with students that certain facts are not in dispute at a time where facts are, the very existence of facts are called into question. I want to take the questionability of facts off the table. So the fact that home ownership tends to be more likely among white families than black families, that's a statement of fact. I encourage folks to use random name generators for hypos and exams to make sure that you are not using just the classic John and Jane or X and Y. Reach out to local and national colleagues, not just as guest speakers, but also as support. Each of us tends to have hopefully one person in our law school on the faculty that we can go to and say, man, I said something stupid in class today, or I wish I could have gotten the students to talk. What should I do? But don't hesitate to reach out to national colleagues as well. If you have, a few people teaching in your area and you say, I need help thinking about how to integrate race into a discussion of a topic, what do other people do? Email is great for that. And my final, I can't go to the don'ts. I have to end with Dorothy Brown's do. Dorothy Brown's advice is do what you feel comfortable with. You do not have to spend an entire class, an entire semester, and an entire anything talking about race. Do what you feel comfortable with. Dorothy Brown's advice is, well, you might start the first time with 20 seconds, and maybe that's enough. Maybe you never advance. Maybe you then move to spending 2 minutes and talking about race in the business org's tax, or 5 minutes. Do what it feels authentic, comfortable, and right to you. Don't set the bar so high for yourself. Aha, so now my don'ts. Don't be afraid to make and acknowledge mistakes. I think Professor Boles was generous in sharing with all of us a time when she felt she had made a mistake with a student. I most certainly did make a mistake once when I described the Internal Revenue Code as having a multiple approach to taxation that I characterized as schizophrenic. A student called me out right away in the chat of Zoom, as Phyllis Tate mentioned students doing, and said, Professor, that's not okay to use a term like schizophrenic. And I immediately noticed the comment and said, you're right, I'm sorry, I should have said the tax code is of two minds. So I think just when you make mistakes, just acknowledge them. Sometimes you can do them, sometimes it's appropriate to do so at the time. Sometimes you might need to reflect, and sometimes one-on-one conversations are more appropriate. Never, 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 never ask a student of color to represent their race. Never turn to, never either by implication or explicitly say, hey, this is a case about a discrimination against blacks. Let's hear from the black students. That would be the worst thing you could do. And don't de facto call on the black students either. Stick to whatever your system is. If you're going alphabetical, then keep alphabetical and don't skip over just to the black student. Don't ask anyone, hey, I see, could you speak how Asians might view this case? No one can speak for their race. Never, ever, ever ask a student to represent their race. If you want to bring a perspective into the classroom, again, and students aren't raising it on their own, bring it up yourself. Have an outside source to bring it up, have a guest speaker, etc. And as a corollary, of course, we can't assume that students have particular perspectives because of their own visible identities. I think we all have had the experience of knowing women who say they are not in favor of feminism, they don't see why gender equality should ever be an issue. But ditto, don't assume that your students of color have particular political backgrounds, particular economic backgrounds. All I can do with my data is talk about median and mean household income. That doesn't mean any particular student in my class comes from a particular background. One thing that's hard for all of us to manage, I think, is the fourth on my list. Don't be silent in the face of classroom displays of racism, sexism, or other forms of discrimination. Students are watching us and watching how we respond. So occasionally students will respond to each other and say that's not what another student said is unfair or racist or discriminatory. But if a student doesn't do that, and or if a student does, we who are responsible for the classroom can say things like this. Here are two of my go-to phrases. Multiple perspectives in my classroom are always welcome, but let's keep the discourse elevated. Or that kind of language is not okay in any law school classroom. I had one student once call another stupid. And at the moment, I just paused and said that kind of language is never okay in the classroom. Why don't you take another shot at rephrasing that? And the student said, I think the other student's opinion is misinformed. And just my last don't say or do nothing. Do what you can. It might be 20 seconds. It might be one slide. It might be one statistic, but don't say or do nothing. There is a phrase in Irish which is, you are the place I stand on the day when my feet are sore. And that is meant in Irish-speaking parts of Ireland as a way of saying, I trust you. You are the place I stand on the day when my feet are sore. But I think this is also the approach an approach that I apply more broadly. In other words, we are all in this together. We each are the place where each of us needs to stand when we are tired and find this work difficult. But together going forward, we can help each other feel a little less sore. Thank you very much.
Thank you so much, Professors Boles and Crawford. So now we are going to start the Q&A sessions. So please, everyone submit questions via the Q&A feature. So because we're going to take about 30 minutes Q&A session, if there are enough questions. Okay, so let me start with the first question to the entire panel. So we talked about how we can deal with the DEI issue in a given upper level classroom. But, I actually shared the same concern with this student question. How can we improve diverse population in upper level classes? So in some ways, students seem powerless, but we can see how important diverse population is for legal education. And let me add my experience to this question. So I'm also teaching tax law and mostly business related law. So I see less female students and less color of people students in my upper level, especially business oriented law classes. I would welcome more diverse students because I'm also a people of color and also female professor. And I think I can, provide more, insights and, healthy dynamic discussion with my students. However, is there any way we can improve the diverse population at the beginning? Professor Crawford? Okay.
Yeah, I'll take a stab at that one. Anytime I have the opportunity to introduce myself to the student body, at the beginning of the semester, each year we always have a sort of faculty lineup where each professor introduces themselves to the full school, and I always say that I teach money law, and here's what that means. And you may think that you have no interest in those courses, but there is no way to be a true expert. There is no way to dismantle the master's house unless you use the master's tools, to use Audre Lorde's famous quote. So if you want to be a public interest lawyer, the tax code is your best friend. Ditto corporations. So I try to sneak that in every time.
Professor Boles?
I think this is a great question. And thank you, Professor Kim, for adding your example. I think this is where the institutional structure is really important, and that the institution can do a lot to demystify what types of courses are kind of appropriate for certain types of people. And so Professor Crawford, like your learning objectives in your tax course that were very explicit, I think that there are ways that the institution can help market courses to a more diverse group of students and really help explain those connections. Because I would have traditionally said something like, the professors teaching those courses can be more involved, but I think we've explored the ways in the last couple of days that certain professors are stretched so thin. And so I think this is where we really need to think within the institution about, the concept of horizontal integration and vertical integration. How do we bring these issues? How do we draw connections horizontally so we see how they connect? How do we take them throughout the curriculum? Because students should understand why, if they want to work in public interest, they need to understand tax. Right? That should be something that we are explaining to students in the beginning. So I think it's in the way we structure and talk about the curriculum. And especially I was a first generation law student, I didn't understand what case, classes to take. And so you go for who's the favorite, right? And that isn't necessarily where we are going to get the most diverse voices included.
Thank you so much for your insightful answers. And the next question is from an anonymous attendee. So how do faculty include these difficult conversations in the Zoom environment where this level of personal engagement is already challenged? So would you like to share your experience? Professor Boles, would you like to go first?
Sure. So I think that was part of the challenge and kind of what I was talking about with my race and the law example, where Zoom is both a way to be more intimate, but that intimacy can be very tiring. It can be exhausting in its own right. And so I think we have to recognize that all of that kind of increased contact, especially for certain people when their experiences are highlighted, it can be hard. And certainly, it's for one student being able to see the cat kind of crawl across the keyboard, everybody laughs. For another student, I had a student experiencing housing insecurity. And so being in a hotel room was very, that was very painful to her on Zoom. Normally we wouldn't have known that, right? Because she would have come to class. So I think that's one thing, just really being cognizant of the different experiences that students are going through. I also liked to start with a little bit of a fun question. I called it the pre-class question, and it would be on some random topic. I taught last week on Zoom, and I said, tell me your favorite state fair food, because we were going to the state fair, and it came out how many of my students had experience with families who worked in the state fair. And so I found, and I actually had them submit the questions last year. So it wasn't always me. So they were submitting questions. And so I think that balance of kind of informality with understanding where people are is a really great way to introduce, right? That sets the stage for these conversations. And then the last thing I will say is, as much as you can structure it. So I try never to just say, what do you think? Right? Like, oh, here's a very difficult, nuanced question. What do you think? And so Zoom forced me to think through some very structured ways to get to class discussion using Google Forms or the chat or discussion forums or breakout groups that I have carried back into in-person classes.
And I'm going to second Professor Boles' recommendation of the Zoom breakout rooms. So my wills and tax classes typically have between 90 and 100 people in them. And I have found that what happens in small groups is very different than what happens in big groups. So one thing I do on Zoom is exactly as Professor Boles said, develop very specific directed questions. I'll then send the students into breakout rooms of maybe 4 students, and I'll give them a leading question. Each of you has to say what month you were born in, and the person whose birthday is the closest to whatever month we're in, you're going to be the group reporter, and I want you to discuss this pinpoint question. How would you have argued that the plaintiff's race or gender did or didn't factor into this decision? I don't ask them, how do you think it mattered? I ask them, how would you argue it? And then have some sort of arbitrary way, whose birthday is this month or the closest to this month, to come back and be the reporter for the group. And I find once I make the question less personal, how would you best argue that blank? And that I don't let the groups choose their own leader. That often helps. Tiny strategy, but it is something that I don't find as easy to do in a physical group of 100. I'm now teaching in the hybrid method, so I've got about 80 students in front of me, 20 on Zoom, and I can't break the 80 students up into small groups because we're still trying to maintain a little bit of social distancing. So Zoom opens up some opportunities that I find that the live classroom did not. I'd be curious to hear what other folks do as well.
Yes, thanks for sharing your experiences. I'm learning a lot myself from Professor Boles and Crawford, and I also felt that making the Zoom environment more comfortable is the first step to make this difficult conversation more comfortable in the Zoom. So make the inclusive environment in the classroom first. I think that's the default that every professor must do, as early as possible in the semester. And I'm also share the challenge about the hybrid classes. So we professors learn how to make the environment more comfortable and engaging via Zoom. And now we are confronting another challenge, the new challenge of the hybrid class, where we cannot use the same Zoom technique that we learned over the past year in the hybrid situations, such as the breakout rooms or other, the personal touch of the Zoom students. So I think that must be an ongoing conversation among the faculties, because I think the legal education will eventually, adapt to the hybrid online, hybrid in-person and online education. Thanks for sharing your experience. Okay. And the next question that I like to ask to the panel is, how it's a bit repetitive, but I think it's an important thing. How can professors encourage students to speak up when needed? So we learned from Professor Crawford or Professor Boles' experience that we shouldn't ask certain students to represent their group of identity. However, as a professor, I think it's also important to encourage students, regardless of their, identity group, to speak up when needed. And how can we do it? Is there any special, skills that you have or know-how that you would like to share?
I do not have any special skills. I fail miserably in every class. I love Poll Everywhere, the polling software for classes, because when I've got 100 students, I can't have them all talking at the same time. And even if they were jumping out of their seats to talk, which they are not, I couldn't, but I can ask them all quickly on a Poll Everywhere, or through, some folks still use clickers. Do you think the result in the case was fair? And then ask someone to volunteer to say why or why not. And sometimes I'll just simply ask someone, take the other side. You thought it was fair, but please give the best argument that it was unfair. So I don't have a good method for in-person encouraging folks to speak up in the ultra big classes. I do admit that I rely on the technology a lot. I also rely on the panel method instead of the cold call. I used to cold call students. I shifted from the cold calls to a card deck, where I would just shuffle the cards and take students' names out. And that was very stressful. So I've moved to the panel method. So sometimes it makes it easier to say, hey, panelists, even if you don't feel this way, I need you to represent some views today. I need some of my panelists speak up, and then I can make eye contact with those 5 or 6 students, and that sometimes helps.
Thank you. How about you, Professor Boles?
I'll add, so I do the same strategies that Professor Crawford does. I use a variety of polling software almost every time. So I'll use clickers, Poll Everywhere, Google Forms. I really try to give different ways to answer. And I just asked Amanda to share in the chat Liberating Structures, which is a free website that has a group of 33 mini structures. And one of them is based on Think, Pair, Share, which I'm sure all of us have done, but there's a lot of different structures you can use to get a variety of perspectives. And so in employment discrimination, I've used one called the Fishbowl, where I asked for volunteers beforehand if you've had an experience with workplace sexual harassment and you're willing to talk about it. And a lot of students are very willing to talk about it. And so for a period of class, I just interviewed those students. They just talked about their experiences. There was not interaction. It was really looking into their experience. It was very powerful. And I don't think I would have had that idea. So sometimes I'll just go through that website. It's a book, but the structures are described on the website to give myself ideas about how to structure discussion in ways that include a range of voices.
Thank you so much. So I'd like to move on to the next question. So we talked about how to improve our system and how law professors or faculty members can make our efforts to make our environment more inclusive. And then now I'd like to move on to what students can do. So how can students make change in their institution? How would it be effective for us to do more research and share stories in class if we can't rely on like commonly used casebooks to present that information? So this question actually was raised in the previous panel, but I think it's also an important issue that we can discuss in this panel. Professor Boles, would you like to start?
I think that is a central question, right? And I think that as much as students are comfortable doing that, then you should, because you're training to be advocates. And so if you're seeing that there's not discussion in class, then you should bring that perspective. But if you're not comfortable, then think of other ways that you can do that. Going to the administration or going to another professor that may not be teaching that class, but may be able to bring ideas. Certainly, talking with one another. So you should push yourself to do it, but understanding that there can sometimes be at least a perceived power imbalance, trying to make sure your voice gets heard in other ways. And I would also just, again, encourage everyone to think beyond the classroom. Much of the law school environment just does not happen in the confines of class. And so the organizations that you support outside, the clinics that you want to be part of, the externships, in our school, this new court observation program. I think at first I think a lot of people were supportive, but a lot of faculty are asking me about it because students are asking about it. Students are asking them and really wanting. So you have a lot of power. You have a lot of power, even if you feel like you don't.
And I would follow on with that advice to students: own your power, own that power and assert it. It's interesting because at my school is mostly a commuter school. People tend not to live in the area where the law school is. There's a small number that live on campus. So students are holding jobs, working full-time or more, and balancing families. And so the natural tendency, to the extent that you can, might be to try to organize online. I would say that would be the least effective method of effectuating change in the school via a Facebook group or something like that. It's not going to reach the faculty, but student group events, sponsored events, even if you're at a commuter school like I am, we do have a common hour where on 2 days a week, student groups hold events. And if you want your professors, your criminal law professors, for example, to get more sensitive to talking about rape, if the student organization sponsors a program and invites 1 or 2 sensitive faculty to come in and start having the conversation, the administration does notice when the student groups organize something on the ground. They won't notice what's going on online, or it's tempting to disregard it. And it's also hard for any one student to say, okay, I want to be the one who challenges the way the entire school teaches rape. But what you can do is gather with like-minded students and sponsor programs if you have the equivalent of that common hour or a group meeting time. So own your power and exercise it, especially through groups if you want. And that also gives individual students cover, so to speak, when there is the power imbalance. You do have to come to professors for recommendation letters and things like that. And so exercising your power as part of a group can sometimes be an effective way to do that without sticking any one neck out too far.
Thank you so much. And now I'd like to ask the last question for this panel, which could be a tough one for we professors, for us professors. It's about test and grading. So how does the traditional law school assessment method, the final exam worth 80 to 100% of a class grade, that traditional assessment method play into this conversation? How can we change the way professors approach assessment to be more inclusive of underrepresented groups, different learning styles, etc.? So I would like to start my own experience. I also usually use the final exam about 80% of my grade, except the seminar course, of course. But I usually include a participation grade, and with that, I think even if it is 20% of a grade, students really pay attention to that participation grade, and with that, I can constantly keep in touch with my students. Sometimes I just say a student who is a bit behind of the participation score, saying that, hey, well, just heads up, it would be great if I can see you more volunteering in class. You are currently in this level of the participation score, but this is not like the one that I would like to line up the students based on their academic excellence in the classroom. It's like I'd like to make my classroom more engagement and active using this participation score, and we are all on the same page understanding this mechanics. So why don't you volunteer more? And that is not just about participation score, but students engaging more, and that actually reflect on their final exam. And so that's the way that I can still obey by the traditional assessment method, but make my classroom more inclusive. But still, I think introducing more formative assessment technique, like assigning more writing or short memo assignment or quizzes, those could be more helpful, but depending on the subject. So could you share your experience with us? Professor Boles? Okay.
I'll go quickly. So I agree with both participation and formative assessment. I think the participation, you really, as Professor Crawford was saying, just kind of really going through and figuring out the panel system and figuring out who is getting called on. In upper level classes, I think we have a lot, we can really push the envelope on this and think of really creative ways to grade. And for the seminar I just taught, we did video presentations, and I mean, my students are so much better at video and technology than I am. So it was really a chance to bring in those strengths. And I, for every single course, have a policy essay. So even in civil procedure and evidence, upper, non-required courses, since we talk so much about these diversity issues, whatever you want to call them, I spend a lot of time in class, and I really push my students to think about it. So then I include that in the grade, right? So I'm not going to spend class time and tell you it's important and then only, test on black letter law. So up to 20% of my exam is either a directed or open policy question where you get to bring in your perspective of from the course. And after almost every class, students are at the podium saying, would this be a good, you really want to know what I think about this? And so I say it right in the beginning of the semester, we're tackling these issues, we're tackling them all semester, and then it's going to be a part of your grade. So I think if we're serious, then we have to also, bring it into the grade, right? We have to bring race issues and diversity issues into the grade in the ways that our students see them, not just how we see them.
Yes to everything that has already been said, but I also want to acknowledge that stepping out of the traditional mold of one final at the end of the semester can be a risky choice for a professor who is untenured or who doesn't have security of position, because not all students want multiple assessments and will sometimes, either through their course evaluations or other methods, make their displeasure known if that professor is doing anything other than the traditional one exam at the end of semester. For 5 years in a row, I have asked students at the end of the semester, in which they are going to be assessed. Yes, I know you only have your grade composed of class participation and the final. Some semesters it's only the final, but knowing what you know now, if you had the option of having 2 midterms and a final, would you have preferred that? And 80% on average say no over a 5-year period. So as much as I think many of us would like to do multiple assessments, when it comes down, at least on my unscientific survey, students have rejected the notion. Students have also pushed back very hard in a class of 80 to 100 people, the notion of class participation, because the size is so daunting. So I have moved away from class participation in the very ultra large classes, and I'm talking ultra large, 90 to 100 people, and especially when I started one semester using absences as a proxy for participation. By definition, if you're not there, you're not participating. Well, the reason some students aren't there is because they're taking they are at home with a sick child, taking someone to a doctor's appointment, et cetera, et cetera. So I am completely confused about what to do in the big class. In the seminar, I have students write reflection papers and are graded on class participation, and they can write as many reflection papers as they want, and I'll take the 6 highest grades because I don't have to grade on a curve. But I say, even as someone who has tenure at my school and has a university distinguished professorship, I have been reluctant to embrace a multiple assessment model in the large classes because the students have indicated they don't want it. So again, students, exercise your power and exercise it through student groups. If all the first year professors for crim law did that, or property law, or torts, or whatever, or if it was known that every upper level class of involving tax always had multiple assessments, I think getting the professors united within a particular subject matter could also help, and so own your power and exercise it. Thank you for that troublesome question that continues to keep me up at night.
Thank you so much. So that concludes the panel of upper level curriculum. Thank you so much, Professor Boles and Crawford, for wonderful presentation and discussion. I learned a lot myself, and I think I should turn the podium to Amanda to conclude this symposium.
Thank you, Professor Kim. I want to thank our incredible panelists and our moderators for their thoughtful engagement with this critical topic. And I want to thank all of our attendees who have been able to join us in discussing our history of legal exclusion and our resistance to DEI, and both the struggles with and the ways in which we can most effectively incorporate DEI into the legal curriculum. This has been a fantastic 2 days of illuminating and powerful discussion that would not have been possible without our fantastic events team, Chris Monty, Tricia Kirschenman, Charlie Stewart, and Spencer Cope, our editor-in-chief, Kate Morgan, our faculty advisor, Rennell Anderson-Jones, and our faculty cohort, Dean Elisabeth Kronk-Warner, Professor Tenille Brown, Professor Beth Jennings, Professor Erica George, and Professor Christine Kim. I also want to give a very special thanks to Professor Leslie Culver, whose creativity, vision, support, and energy were absolutely essential to making this event a reality. So this now concludes the 2021 Lee E. Teitelbaum Law Review Symposium. Include their stories, Rethinking, Reimagining, and Reshaping Legal Education. Thanks.